Assalamualaikum warahmatullahi wabarakatuh to Dr. Mazril and fellow classmates. We are from Group 2 and we're going to present the case study 2. Case study 2 is about Normala, who is an employee at an electronic company in Serembantu, and she was pregnant. So 10 days before her expected maternity leave started, Normala was very unwell and she went to see her doctor, and the doctor advised her to have a bed rest for 3 days. Then she told her supervisor that she would like to commence her maternity leave 1 week earlier because of her condition, and her supervisor was not pleased since it could affect the company's production. After completing her 60 days maternity leave, Normala was still in a bad condition and was diagnosed with postpartum psychosis by her doctor. She was given another 1 month leave, but her condition was getting more intense. Later on, she received a termination letter from her supervisor, which makes both Normala and her husband dissatisfied. So they decided to claim for unfair dismissal.
Okay, so for this case study, I will start with Part 9 of Employment Act, which specifically explain on the maternity leave, maternity allowance, condition, and also the restriction of dismissal of the female employee after the maternity leave. So there were 2 provisions that can be used for question 1, where the first one is Section 37, subsection 1, subsection A of Employment Act, which stated that all female employees are entitled to maternity leave and also the maternity allowance. And then the second provision is Section 37, subsection B, which subject to Section 40, that stated that the maternity leave should not commence earlier than 30 days. Okay, however, if the medical officer has certified that she unable to perform her work satisfactorily because of her pregnancy, then she can ask for a maternity leave from her employer in between 14 days before her confinement date. Okay, so for Normala case, she is being unwell for 10 days and then the doctor asked her to bed rest for 3 days, which this situation shows that she was unable to perform her work satisfactorily, and then it has been certified by the medical officer that she cannot perform her work satisfactorily. And then according to the Section 37, subsection 1, subsection A, she can apply for the maternity leave as she is one of the female employees and she was entitled for the leave. And then according to the second provision, which is the Section 37, subsection B, where she asked for the maternity leave to her employer a week before the confinement date, and then as explained in the provision that she can ask for the early maternity leave 14 days before her confinement date. So this situation showing that she has fulfilled the requirement for the provision, and then she was entitled for the early maternity leave.
So now let's move to question 2, which is explain the maternity protection given to women under the Employment Act 1955. According to maternity protection in the Employment Act 1955, female employees are entitled to get maternity leave and maternity allowance regardless of their salary. It is stated in Section 44A in Employment Act 1955 that maternity protection is applicable to all employees regardless of their wages earned. Therefore, it is mandatory for employers to comply with these provisions. Every female employee is entitled to at least 60 consecutive days of paid maternity leave for each childbirth. Confinement simply refers to the process of giving birth to a kid after 38 weeks of pregnancy, whether alive or dead. The female employee will still be eligible for maternity leave after that. Such maternity leave, on the other hand, will be considered as unpaid leave. If the maternity leave must be started sooner than the authorized term for medical reasons, the leave will be recognized as unpaid leave unless it can be proven as yearly leave, medical leave, or other paid leave as prescribed by the Employment Act or as provided in the employment contract.
As for the Normala case, from the Section 44A in Employment Act 1955, Normala is fit to get her right about the maternity protection because she meets all of the requirements. Firstly, Normala is a pregnant woman, and even though she is just a production operator and not the employee of the company, she is still visible with it because the condition of the Section 44A in Employment Act 1955 applicable to all regardless of the wages. Next, for the maternity leave, Normala has a right to get a proper maternity leave even a week before the expected date because in the Employment Act, it is written that the maternity leave should be after 28 weeks of pregnancy, whether the baby is alive or otherwise. Next, Normala also has a right to get the leave for another 1 month because she has a permission and letter from the doctor who treats her about the postpartum psychosis. In this situation, Normala's employer should give her unpaid leave and not give her a termination letter for not being able to go to work. The employer can only terminate her from the company if she does not have any medical letter from the doctor who treats her. From Normala cases, she has a right to take an action and claims for the unfair dismissal because her employer has already violated the Section 44A of the Employment Act 1955.
So Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Khairul Zambi Abdul Jalil and I will discuss about our question 3 with my partner Najwa. So according to section 42, subsection of the Employment Act 1955, a female employee may remain absent from her work after the expiration of the eligible period due to the illness certified by a registered medical practitioner to render her work unfit for her work. It will be an offence for her employer to terminate her service or give her notice of termination of service until her absence exceeds a period of 90 days after the expiration of the eligible period. Thus, under this provision, every female employee can remain absent from work for not more than 90 days after the expiration of her confinement if she is diagnosed by any illness from her pregnancy and confinement by any registered medical practitioner. Hence, no termination can be done by the employer if the female employee still does not exceed the 90 days period because it was stated in the law and the female employee has rights to take that leave. If any termination happens during the 90 days, a legal action can be taken towards the employee. The termination can be done if she exceeds the period of 90 days after the expiration of her confinement leave.
So, in Normala's case, she was given another 1 month of medical leave right after her maternity leave ended as she was diagnosed with postpartum psychosis by her doctor, and because of that, she was dismissed by her company. Applying the previous provision, which is Section 42, Subsection 1 of Employment Act 1955, it is an offence for the employee to terminate her services since she was absent because of the illness arising out of her pregnancy and confinement. The provision stated that every female employee has the right to remain absent from her work as long as not more than 90 days after the expiration of the maternity leave if she was diagnosed with illness arising from her pregnancy or confinement. Also, the employer cannot simply terminate her services. Furthermore, the additional leave is still within the period of 19 days after the eligible period. So there is no issue that Normala has exceeded the leave periods and the employer has no rights to terminate Normala's services.
Hi, my name is Muhammad Syarif Ikhwan, and in question 4, we will talk about the social security benefits that are available for Puan Normala. Currently, maternity benefits are governed by the Public Service Circular on Maternity Leave Benefits, which was enforced on 15 October 2010. The circular underlines that a female employee is entitled to fully paid maternity leave of maximum 300 days throughout her service. The employee are also given the flexibility to determine the period of maternity leave between 60 days to 90 days for each confinement. And lastly, the employee are entitled up to 1,825 days, which is 5 years, of childcare unpaid leave throughout her service, under the Public Service Circular on Childcare Leave with effect from 3 September 2007.